4 Mayıs tarihinde İstanbul'da başlayan etkinliklerimizin devamı olarak gerçekleştirilen bugünkü ve yarınki oturumlarımıza açılış konuşmalarını gerçekleştirmek üzere Türkiye Barolar Birliği Başkan Yardımcısı Sayın Avukat Başar Yalçın'ın kürsüyü teşriflerini arz ederim efendim.
Dünyanın öbür ucundan gelen sevgili dostlarımız, değerli konuklar, hoş geldiniz. Barolar Birliği Başkanımız Metin Feyzoğlu'nun daha önceden planlanmış bir programı nedeniyle bugün burada bulunamadığını belirtmek ve selamlarını iletmek istiyorum. Zannediyorum yarın akşamki gala yemeğimizde kendisi aramızda bulunacaktır. Hukuk artık toplumların, devletlerin ortak kültür değeri haline geldi. Dolayısıyla hukuk konusunda görüş alışverişinde bulunmak, hukuk sistemlerinin birbiriyle ilişkisini görmek, bunların yakınlaşmasını izlemek ve mümkünse hukuku bütün alanlarında bir ortak değer olarak benimsetmek hepimiz için görev diye düşünüyorum. İnsanlık için bir görev diye düşünüyorum. Bu nedenle Bahçeşehir Üniversitesi ile birlikte uluslararası olarak düzenlenen bu konferansın çok yararlı olduğunu değerlendiriyorum. Bu çerçevede konferansın gerçekleşmesinde büyük emek veren Bahçeşehir Üniversitesi'nin tüzel kişiliğiyle birlikte asıl ona can katan Feridun hocamıza çok çok teşekkür ediyorum. Türkiye Barolar Birliği adına da üstelik de çok kısa bir sürede aynı katkıyı sunan yönetim kurulu üyemiz Gülcihan Türe arkadaşımıza bu organizasyonu gerçekleştirdikleri için teşekkür ediyorum. Konferansın burada çok daha anlamını bulacağını değerlendiriyorum. Çünkü uygulamacılar da aramızda olacak, avukatlar aramızda olacak, dekan hocalarımız aramızda olacak ve konferans gerçek anlamını Barolar Birliği çatısı altındaki 2 günlük sürede bulacaktır diye değerlendiriyorum. Tabii buradan çıkacak sonuçları da hep birlikte değerlendirip belki de bir yayın haline getirebiliriz. Çok şey öğreneceğimizi düşünüyorum. Hepinize hoş geldin diyorum. Saygılar, sevgiler sunuyorum.
Sayın Başkan Yardımcımıza konuşmaları için teşekkürlerimizi arz ederim. Programın genel sunumu Sayın Dekan Emeritus Tom Reed tarafından gerçekleştirilecek. Kendisinin kürsüyü teşriflerini arz ederim efendim.
I want to thank our Turkish hosts for the wonderful hospitality they have shown us. It is a joy for the Americans to be here. In 2001, on Heybeliada Island outside of Istanbul, we had the first of a series of meetings where we legal educators from around the globe were trying to think about what legal education would be like in the next decade. In a real sense, this is a successor meeting to that. We are here again looking for good ideas from one another. Now, I'm going to give you the key to making this conference successful. You've got to be aggressive and you've got to be willing to ask questions. You've got to be willing to probe. So what I'm going to do is kind of act as a policeman for each panel. I would like each panel to at least allow 10 minutes after each panelist has spoken so that we can ask questions, all of us. We all have great strengths in our legal systems and our legal education systems, but we all have weaknesses. We learn from one another. And so from both sides, from across the pond and from the Turkish side, don't hesitate to raise your hand and ask questions, and we'll try to provide for that questioning period at least 10 minutes after each panel. And before I step down, I want to single out a single human being who's done more to bridge the waters and bring our systems together. A man committed to students finding places abroad to study and bringing them back with new educational ideas. A man who has just been an inspiration on both sides of the Atlantic, and that is my very close friend, Professor Dr. Feridun Yenisey. We have a very special guest from the United States who runs an extremely important organization, and he's threatened me if I introduce him that he'll be very angry, so I'm going to introduce him anyway. He is my very close friend, Dan Bernstein, who is president of the National Law School Admission Council, and that council provides admission tests to all applicants to law school in the United States and Canada, and Dan is watching today. Dan Bernstein. I'm going to now turn to each panel and let each panel introduce themselves, and the panel chair will do that. Again, the important thing is if you have a question, hold it, write it down. Don't hesitate to interrupt and ask questions at the end, or to ask questions at the end of each panel. We learn from one another, and the whole point of this is to exchange ideas and get more familiar with each of our systems. And so I turn it over to our first panel, which is on the state of legal education across the globe, and they'll get us started.
Sayın Profesöre teşekkür ediyoruz. Böyle güzel bir organizasyonun içinde bulunmaktan, çok değerli yabancı misafirlerimizi, bilginlerimizi dinlemekten son derece istifade edip memnun olacağız. Burada hakikaten globalleşmenin kesin bir örneğini görüyoruz. Eskiden uzaklar uzaktı. Yakınlar yakındı. Şimdi uzaklar yakın oldu. Globalleşmeyi ben uzakların yakın olması olarak anlamak istiyorum. Dünyayı bir anda görmek, dünyayı bir anda ayağımızın dibinde bulmak, karşılıklı etkileşim içinde bulunmak, her iki tarafa, herkese, her birime muhakkak ki büyük faydalar sağlayacak. Burada bugün bunun güzel örneğini hep beraber yaşayacağız. 15'er dakikalık aşağı yukarı, sonunda 10 dakika, 15 dakika bir soru cevap payı bırakmak üzere 15'er dakika konuşma payıyla ilk sözü Profesör Doktor Moliterno'ya veriyorum. Buyurun efendim.
Thank you very, very much for the wonderful welcome. I am most honored to be here in your wonderful facility. I think it is wonderful that the Bar Associations of Turkey have such a marvelous place to host visitors and to host conferences like this. I think it's wonderful. My wife and I landed in Istanbul just a few days ago, and it was our first time in Turkey. And I felt very comfortable. I felt very much at home, partly because of the welcome of the warm people here, but partly, perhaps, because all four of my grandparents are Mediterraneans. And I found that as my wife and I began to walk on the streets of Istanbul, I was frequently mistaken for being Turkish. Even Professor Yenisey confessed that when he first saw me, he thought perhaps I was Turkish. So I feel very comfortable here. I'm very proud to be mistaken for Turkish. I'm going to talk very, very briefly. I would love to have your questions, as Dean Reed talked about. I'm going to talk very, very briefly about the background of American legal education, a very short history of it, and then tell you about our current conditions in American legal education, which are actually in a troubling time for us. So this is called the American Legal Education in Crisis. It's drawn from my Oxford University Press book of just this past year, which is more broadly about the American legal profession and how it has reacted during times of crisis. Unfortunately, the way the American legal profession has reacted during times of crisis is to try by different means to stay the same. It always wants to stay the same, despite the fact that the world is changing around it. And of course, any institution that tries to stay the same when the world changes around it eventually loses. And it must change as society and culture, global trends change all around it. So very, very briefly, how have we gotten to where we are in American legal education? 200 years ago, a person became a lawyer in the United States by being an apprentice to an existing lawyer. There were very, very few universities that had law faculties or law schools, and almost everyone who became a lawyer by becoming some current lawyer's apprentice. Just like someone might become a shoemaker or another tradesperson by attaching themselves to a current person. The most important reform in American legal education occurred in the 1880s, when the Ottomans were still in power. In the 1880s at Harvard Law School, American legal education was reformed, and it was made into a kind of science. It was then that we began to get scientific methods into the study of law. We learned over time that interactive methods of teaching were superior to simply having some professor lecture to you, where there was only one voice in the room, and that was the professor's. And over time, we have developed these interactive methods so that now, today, we spend a great deal of time in American law schools putting the students in the role of a lawyer and creating situations for them in which they can themselves play the role of a lawyer and do the lawyer's work under the guidance of their professor. So in a way, we have brought back the old apprenticeship, but we have done it inside of universities rather than in the lawyer's office. Today, we are experiencing a very difficult time in American legal education. Our applications for students to come to law school are at a 30-year low. They have fallen 4 years in a row by more than 10% each year, so that we are now seeing applications at about the same rate as occurred in the 1970s and 80s. There are demands from everywhere, from law firms, from bar associations, from the students themselves, to make law school more practical, more relevant, more able to prepare the students for the work that they will do when they graduate. It's also becoming very expensive in American law schools, and as a result, there are demands for the cost to come down as well. Our crisis in American legal education, although it seems to be very recent, has very deep roots. In those 1880 reforms, when Harvard Law School reformed legal education, medical education was also being reformed at the very same time. Medical education at that time decided that its mission would be to create doctors, to serve the society. Legal education, at the same time, decided that its mission would be to create law professors. It would be a purely academic exercise, one that distanced education from the actual practice of law. We are still 140 years later trying to recover from those choices. We are still trying to find our way back so that we can have a connection with the practice of law. Many people are to blame for our current difficulties in legal education, and everyone has some favorite person or group to blame. Some think our current problems are the fault of professors who have been selfish, who want to teach very little and want high pay. Other people think it is the problem of universities who have wanted to earn a great deal of money from their law schools. Some say that it is a problem of our accreditation system and our American Bar Association that sets the rules for what law schools must be like. Others think it is the fault of corporate clients in the United States who have stopped paying for the work of beginning lawyers, and as a result, law firms have stopped hiring very many beginning lawyers. In any event, there are many possible entities to blame for the current difficulties, and it is probably a little bit of each that is truly to blame. As we have seen the demand by law students to come to law school, applications have gone down, we are beginning now to see the price, the cost of legal education come down. Many law schools are beginning to reduce their tuition, and other law schools are finding ways to give discounts to law students who want to come and attend their schools. Some people have suggested eliminating the third year of our 3-year graduate legal education, our JD degree. Even our President Obama has recommended that that be eliminated. But other schools like my own, and I'll get to talk about this afternoon, have decided to make the third year a practical year. Make the third year a time when students can be prepared for the practice of law. Some people have recommended changes in our accreditation standards that can make law schools run more like businesses and less like university departments. Finally, our American legal education system truly is an excellent system in that it involves interactive learning and experiential education with our students. But it is still so much short of what it could be. I think it is very, very good, but it must be even better, much better than it is now. As we are in this time of crisis, we must do what everyone does, wise people do, during a time of crisis, and that is look for progress, look for reform, look for ways of making what is good much better still. I'll be happy to have your questions after the remarks of my colleague. Thank you very much.
Sayın Profesöre gönülden teşekkür ediyoruz. Genel bir manzarayı çizdi. Şimdi bunun içinin doldurulması için sözü Profesör Jane Ching hanımefendiye veriyoruz. Buyurun efendim.
Right to go through, yeah.
Thank you. Good morning. I'm delighted to be here, and I have to thank my US and Turkish hosts, colleagues, and I very much hope friends, for allowing me to spend some time this morning telling you about developments in England and Wales. And I have to be quite careful to say England and Wales at the moment. As you may be aware, in September, Scotland may be an entirely different country. One of my starting points with new students in my university is to ask them how many legal professions they think there are in the country. And they usually say two. They've heard of solicitors, they've heard of barristers. And then in fact I say to them, actually there are 8, possibly 10, possibly 12 if we start counting paralegals. And under our legislation, we have a multitude of different legal professions. Some of them, as you will see from the numbers, very small. Some of them, in a country of 60 million people, are quite large. And I'm going to talk largely about one of them, the biggest number, the solicitors. So solicitors do most of the legal work. Barristers are the specialist advocates. Legal executives are a profession which began life as paralegals working with other lawyers. They've just, in the last few weeks, received permission from the government to practice independently. So they're now our 3rd largest legal profession. And after a number of government investigations, we now have legislation that tells us how legal services have to be provided. It has objectives which you might think are fairly obvious. They refer to the public interest, to the rule of law, to access to justice, and to an independent and effective legal profession. They also prescribe the kinds of activity that are reserved, that only regulated lawyers can do. And those are comparatively limited. They are advocacy, litigation, some property activity. General advice on contracts, for instance, is not reserved. Anybody can do it. And with 8 or 10 or 12 professions, they each have their own education system. The 2 largest professions generally start with a law degree, and as in Turkey, that's an undergraduate law degree. It's followed by a vocational course, a postgraduate course, which is experiential, which is skills-based, which is about being a lawyer, and is then followed by a mandatory internship, a training contract, a pupillage. Some of the specialist professions, the intellectual property lawyers, for instance, expect people to have science degrees. And some of our professions are very proud of the fact that they will take people straight from school, that they can work and study at the same time, and that is much more like the older apprenticeship model. So this is the model for solicitors, the biggest profession. An undergraduate law degree. And some of those undergraduate law degrees are part-time, some of them are online, some of them are what we call a sandwich. You spend some time in the university, then go and work in a law firm, and then come back. And there's a great deal of debate about whether we should treat the law degree as preparation for the profession or not. About, in some places, 30% of students on a law degree go into the profession, the rest don't. The legal practice course is a year-long, highly experiential, highly skills-based course that involves advocacy and interviewing and legal drafting and so on. And then the training contract is a 2-year, for solicitors, a 2-year apprenticeship with requirements for what people must cover. The moment it's not formally assessed, things may change on that. But as you'll see, we don't have a bar exam, except for incoming foreign lawyers, and I looked up the requirements for Turkish lawyers this morning. Turkish lawyers who want to come into England and Wales need to take a knowledge test and a skills test, which also involves advocacy and interviewing and so on. We've got many similar problems to those in the US. student debt, arguably too many lawyers, or too many of the wrong kind of lawyer. And so in 2011, the three biggest regulators decided to commission a research review of all of legal education for all of those professions. It's an evidence-based review. It involved interviews, surveys, focus groups, quantitative analysis, and was carried out by a team of researchers from a number of British universities, of whom I'm one. And we were asked, or decided, that we would look at these things. What do people currently need to work in the area? What are they going to need in 10 years' time? How can we make sure that those public interest, rule of law, objectives in the Legal Services Act are achieved? Can we have a legal education system that is flexible, that treats people equally, that is equal in terms of social class, for instance? And given that we know things are going to change, can we have a system that can accommodate that change? And as you might imagine, given 8 different professions, should we just give up and have one profession and just call it lawyers? Or should we regulate more and different professions? So I'm not going to talk in great detail about what we did. We looked at the context, what do lawyers do? We looked at content, what were we being told that the legal education system didn't deliver? And we looked at the structures. Where are the barriers? Where is it difficult to move from one stage to another, for example? And we made a number of recommendations, which are in 4 groups. We recommended that we should work to outcomes, work out what it is people need to be able to do on the day they qualify, and then work backwards from that. We made recommendations about content, that there should be more ethics, for instance, more commercial awareness. We recommended more flexible skills. We recommended that students had more information about career prospects, about what they were getting into. And at the moment, the regulators are working on how to achieve all of this. And they are taking on board our recommendations. So things will change in England and Wales in the next few years. If people are interested in looking at the report, this is where you'll find it. I always recommend that you download the e-book, because the main report is about that big, at which point I'm entirely happy to answer questions as well.
Sayın Profesöre gene aynı içtenlikle teşekkür ediyoruz. Amerika Birleşik Devletleri'nin ve İngiltere, Galler ülkesinin deneyimlerini bizim önümüze getirdiler, serdiler. Böylece dünyayı daha yakından tanıma imkanı bahşettiler. Şimdi soru cevap faslına herhalde geçelim. Buyurun efendim.
Teşekkür ederim. Ben her iki konuşmacıya teşekkür ediyorum. Sizlere de katılımınız için teşekkür ediyorum. Türkiye'de ve dünyada hukuk eğitiminin bir önem taşıdığını gördük her iki konuşmacıdan da. Mesela Amerika örneğinde şunu gördük. Çok kaliteli ve pahalı hukukçu yetiştiriliyor 3 senelik bir eğitim 2'ye düşürmeyi düşünüyorlar. Biz ise hukuk eğitimini daha 5 sene daha da fazlaya çıkartmayı öngörüyorduk. Onları düşünüyorduk. Fakat bu 1800'lü yıllardaki Harvard raporu ve Harvard değişimi ilginç. Bakınız, profesör yetiştirmek için eğitim vermeyi planlamış Harvard o yıllarda. Yani sıradan bir hukukçu değil, çok üst kaliteli hukukçu yetiştirmek, profesör yetiştirmeyi öngören bir programlama içerisinde ve pahalı. Şimdi acaba değişen dünyanın ihtiyaçlarına nasıl bakmamız gerekiyor hukuk eğitiminde? Hukukçunun rolü ne? Ve burada İngiliz meslektaşımızın verdiği 3 tane fikir var. Hukuk devletinin temeli, rule of law. Hukukçu bunu sağlayacak. Hukuk devletinin temelini sağlayacak. Bunun için 21. yüzyılda nasıl bir hukukçu yetiştirilmesi gerekiyor? Bütün dünyayı yakından ilgilendiren çok önemli bir sorunu bugün sizlerle tartışacağız. Fakat örnek aldığımız Batı ülkelerinde de hukuk eğitimi ile ilgili büyük problemler olduğunu görüyoruz. Daha henüz söylenmedi ama Amerika'daki hukuk fakültelerinin %30'unun kapanma tehlikesi olduğu söyleniyor. Hukukçuların azalacağı, okulların çok pahalı olduğu, fakat Türkiye'de tam tersi var şimdi. Her 3-4 tane hoca bulan fakülte açıyor. Ve iyi bir eğitim veriyor mu acaba? Kaliteli bir eğitim veriyor mu? Nasıl bir eğitim vermemiz gerekiyor? Bu toplantı bu bakımdan çok önemli. Barolar Birliği'ne teşekkür ediyorum büyük bir destek verdiği için. Atlanta John Marshall'a çok teşekkür ediyorum çünkü bütün bu konuşmacıları onlar getirdiler, onlar temin ettiler bize. Ve dekanlarımıza teşekkür ediyorum, geldiler. Baro başkanlarımıza, yarın da öğrencilerimize. İstanbul'dan 40 tane öğrenci otobüsle gelecek. Esas bizim hedef kitlemiz öğrenci. Bu toplantılar öğrencisiz olmamalı idi. Umarım ki Ankara Üniversitelerinden de katılımlar olur öğrencilerden. Kıbrıs'tan da öğrenciler gelecek. Öğrencilerle birlikte tartışmamız lazım bu hukuk eğitimine geleceğini. Teşekkür ederim.
Bu işin tasarımcısı, planlayıcısı, kotarıcısı ve bizi buraya davet etme şerefini bahşeden Barolar Birliği ile işbirliği yapan Sayın Feridun Yenise'ye teşekkür ediyorum. Bu açılımlar şimdi devam edecek. Efendim, soru cevabı devam edebiliriz. Buyurun.
Ankara Barosu'nda Avukat Cengiz Yaşar. Öncelikle her iki konumuza hoş geldin diyorum. Şimdi sorum her iki konuğa olacak. Hukuk eğitiminde bahsedilirken bence hukuk niçin var? İnsanoğlu hukuk denilen kavramla niçin tanışıldı? Her iki ülkenin eğitim sisteminde de bu konuya hiç değinilmedi. Örneğin İngiltere ve Amerika Birleşik Devletleri'nde Roma hukuku temel ders olarak öğrencilere öğretiliyor mu, öğretilmiyor mu? Çünkü Roma hukuku aslında bugünkü çağdaş hukukun temel varlık nedenidir. Yani hiç kimse sahip olduğu haktan fazlasını başkasını kimseye devredemez ilkesi aslında insanın insana karşı mücadelesinde eşit durmayı ve birey olmayı temel ilke olarak önemsemiş. Ya da ulpiyan, hiç kimsenin hakkını yeme, onurlu yaşa, kimseye de hakkını yedirme bundan 2000 yıl önce derken tamamen insan aklına hitap eden ve insanı insan yapan bir temel duruş sergilemişti. Bugün bizim ülkemizde son 10 yıl içerisinde Roma hukukunun dinsel etkilerden etkilenmediğinden dolayı, örneğin ben fakültede okuduğum sene Roma hukuku çok zor bir dersti. Öğrencilerin en zorlandığı dersti ama bugün ülkemizde son 10 yıl içerisinde Roma hukuku sıradan bir ders oldu. Yani öğrencilere üstünkörü bir ders veriliyor ve öğrenilmemeleri isteniyor. Çünkü Roma hukukunda dinin etkisi yok. Yani ne gerek çok tanrılı dinlerin ne de tek tanrılı dinlerin etkisi yok. Tamamen insan beyninin doğan karşısındaki üretimidir. Amerika Birleşik Devletleri'nde Mauritano böyle bir konuya değinmedi. Sayın Shinks sadece şunu söyledi. Etik dedi, ahlak dedi. Yani acaba biz hukuk eğitiminde kariyer mi önemli, para mı önemli, mevki mi önemli, insani değerlerin öğretilmesi mi önemli?
I'll be happy to tell you what is the beginning coursework for American law students, at least at my school and at most schools. We do not teach the Roman law as a foundational course. We begin by having them learn our constitutional law, contract law, law of obligations, property law, tort law, law of injuries, law of crimes, procedure, court procedure, and international law, and lawyer ethics. So lawyer ethics is a required course at every American law school. Those are the foundational courses at most American law schools. There are some other courses that are often required, but it has become more and more uncommon in American law schools for there to be courses in legal philosophy, Roman law, and other kind of basic courses of that nature, background courses, philosophical and theoretical courses. But lawyer ethics is a primary course, always.
Thank you. In England and Wales, we have a similar list of foundation subjects: contract, tort, land law, equity, criminal law, constitutional law, and European law and human rights. Again, as a common law country, we don't require people to study Roman law. I went to a university where we did, but that was unusual. We have an interesting situation in relation to ethics. In the undergraduate degree, we're required to cover, if you like, values, the social justice. We're not required to cover jurisprudence. We cover our professional ethics, the rather specific professional ethics, once people have decided which profession they're going into in the vocational course. But one of the issues in our report was that we felt there was still some lack of clarity about exactly how ethical social justice issues were dealt with throughout legal education.
Teşekkür ederiz. Buyurun efendim.
Teşekkür ediyorum. Adım Tahir Elçi. Diyarbakır'dan geldim. Diyarbakır Barosu Başkanıyım. Ben de hem Türkiye Barolar Birliği'ne hem Bahçeşehir Üniversitesi ve Feridun hocamıza hem de John Marshall School of Law'a teşekkür etmek isterim bu imkanı bize sundukları için. Benim iki sorum var. Birincisi Profesör Jen Shing'e. Şimdi tabii ben şu ana kadar İngiltere'de ya da İngiltere ve Galler'de ya da Britanya'da neyse avukatlık mesleğinin iki kategoriye ayrıldığını biliyordum. Barrister ve solicitor. Bugün bir de patent avukatlığı ya da işte trademark gibi çeşitli alanlarda da bir uzmanlaşma veya bir kategorileşmenin olduğunu gördüm. Ben şunu öğrenmek istiyorum. Acaba yani barrister ve solicitor dışındaki alanlarda yani bu iki kategorinin dışında yani özel bir alan mı yoksa yani solicitor ve barristerlardan birileri örneğin patent avukatlığında yapabilir mi? Bir de daha çok merak ettiğim şey şu. Acaba mesleğin başında solicitor olan daha sonra fikir değiştirip örneğin barrister olabilir mi? Veya işte patent avukatlığına kayıt yapan, baronun bu bölümüne kayıt yapan bir neyse avukat daha sonra alan değiştirebilir mi? Birinci sorum buydu. İkinci sorum, tam da bu dönemde biz de bir avukatlık yasası hazırlığı içindeyiz Türkiye olarak ve çok köklü değişikliklerin yapılacağı bir ay içerisinde öyle görünüyor ki parlamentodan geçecek. İşte Feridun Hocam dedi ki Amerika'da avukatlık eğitimi 3 yıldır 2 yıla düşürmeyi düşünüyorlar. Bizde bir de staj sorunu var. Staj şu anda bizde 1 yıl ama şu anda meclise sunulacak olan veya staj 3 yıla çıkarılması öngörülüyor. Acaba hem İngiltere'de hem Amerika'da staj kaç yıldır, nasıl yapılıyor, bunu ben öğrenmek isterdim. Teşekkür ediyorum.
Thank you. On the first question, there's a short answer and there's a very long answer. The short answer is that the different professions are regulated to do different things. I'm a solicitor. I could do some advocacy. I can do patent and trademark law. Patent and trademark attorneys can only do patent and trademark law. That's the short answer. The long answer is, yes, you can move from one profession to another. I was the person who, in our report, sat and spent, I think, 3 days looking at all the regulations to try and work out how you did it. And that's one of the reasons why we recommended flexibility, that should be easier to do. In terms of internship, the solicitors have 2 years, the barristers have 1 year. Some of the other professions have different periods of time, ranging between, I think, 2 and 5.
So in the U.S., we, of course, begin with an undergraduate degree, a bachelor's degree in any subject at all. Our law degree is a graduate degree. So my undergraduate degree, my bachelor's degree, was in mathematics. It's common for my students to have undergraduate degrees in history or philosophy or any number of subjects at all, political science, perhaps. After the undergraduate degree, a student is enrolled in a 3-year graduate program, so it is a complete 7 years to become a lawyer, even though the first 4 are spent in undergraduate school in any subject. After the 3 years of law school, there is no required internship time in the U.S., but it is extremely common for our law students to work in the marketplace while they are students, to have jobs in law firms, in government agencies, assisting judges, a variety of different activities that they engage in that allow them to get a feeling of the workplace, the legal workplace. After they graduate from law school, they must pass the bar exam. Once they have passed the bar exam, they are a lawyer. And in the U.S., we have a unified legal profession. So a person can be any kind of specialist they choose to be and learn how to be. So they can do corporate law, they can do criminal law, they can do any manner of legal specialty. They can become an expert in securities and trademarks, whatever they choose. It's also true that in the U.S., unlike many places I have visited, it is very common for an American lawyer to change careers during their lifetime, to become a prosecutor, to become a judge, to finish some part of a career as a judge and go become a lawyer again, a private lawyer. So our profession is unlike many in the world that have particular categories. You are simply a lawyer, and then you make career choices as you go along.
Evet, bizim hiç alışık olmadığımız sistemleri görmüş oluyoruz. Hakikaten ilginç. Buyurun efendim.
Merhabalar. Öncelikle sayın misafirlerimize hoş geldiniz diyorum Türkiye'ye, ülkemize ve toplantıda emeği geçen Türkiye Barolar Birliği'ne, Bahçeşehir Üniversitesi'ne içten teşekkürlerimi sunmak istiyorum. Doktor İhsan Baştürk, Yargıtay Cumhuriyet Servisiyim ben. Şimdi Profesör James Molterno ve Jane Ching'i dikkatle dinledim. Profesör Molterno hukuk eğitimi ile tıp eğitimi arasındaki benzerliğe dikkat çekti. Ben de aynı düşünceyi paylaşıyorum. Hukuk eğitimine olan talebe bakıyorsunuz ve kriz içinde olduğumuzu söylüyorsunuz. Ama diğer taraftan tıp eğitiminde, tıp bilimine olan talepte sürekli bir yükseliş var. Ben şu düşüncedeyim. Günümüzde insan ilişkileri tabii ki karmaşıklaşıyor. Uyuşmazlıklar, ihtilaflar artıyor. Uyuşmazlıklar arttığı sürece bu global dünyada bence hukuk eğitimine ve hukukçuya talep giderek artacak. Yani bu anlamda ben kriz olduğunu düşünmüyorum. Profesör Jane Ching'in belirttiği gibi farkındalık yaratma, yani kamuoyu, toplumu, hukuka olan gereksinim, uyuşmazlık daha çıkmadan çözme yolunda olan gereksinime ihtiyaca farkındalık yaratmanın oluşturulması anlamında hepimize hukuk eğitimine tabii ki görev düştüğüne inanıyorum. Bu kısa düşüncemden sonra Profesör Molterno'ya şunu sormak istiyorum. İnteraktif metotlardan bahsettiniz hukuk eğitiminde. Bu interaktif metotlar nedir? Yani bildiğimiz sanal duruşma mıdır? Onun haricinde hukuk öğrencilerini dersin içine daha fazla çekmek midir? Nasıl yolları başvuruyorsunuz? Ve diğer taraftan ben özellikle Birleşik Devletler'de hukuk eğitiminin 2. lisans olarak verildiğini biliyorum. Bizim de bu yola başvurmamız gerekebilir mi düşüncesi açısından? Amerikan toplumunu bu ihtiyaca iten neden nedir? Onu öğrenmek istiyorum. Çok teşekkürler.
So you asked many wonderful questions, very important questions. The most important one, I completely agree with you that every crisis, this crisis is not an ultimate crisis. This is a crisis that, like every other good time of change, is an opportunity to make our work better. So whenever demand for our product goes down in legal education, we should take that as an opportunity to do our work better and serve our society better. And I think that's what we will do. I believe that is what American legal education will in fact do. You asked about what kind of interactive methods. Almost every American law school class involves the students' participation. It is very, very rare in an American law school for the professor to be the only one who speaks. There are many different techniques for doing this. Because we are a common law system, one very common, very usual technique is for the students to have read court opinions and engage in discussion of those court opinions with the professor. The professor will ask a question about why the judge did a certain thing or why the judge said this in a certain way. And the students will exchange back and forth. And I know I am doing a good class when the students start to talk to each other, answer each other's questions even. So that is the most common. But my own preference, and many, many other law professors today, put the students into short scenarios or role plays. So I might go into the class wanting to talk about the law of conflict of interest in ethics, professional ethics. And I will say to a student, young man, you are a lawyer and you have a client who has come to your office with this kind of problem. And then I will say, now the client's father is calling you on the telephone pick up the telephone, and I will engage them in a back and forth that puts them into the role of a lawyer during the class and requires them to respond as they think a lawyer should. And I will then engage in guiding them through those responses so that they are good responses and they learn what the core legal principle is about, in this example, conflict of interest, by actually having a conflict of interest play out in the middle of the class. So this is becoming much more common. But at the end of the day, there are almost no law classes where only the professor speaks.
I want to thank this panel. This has been an enormous panel. I'm going to let the moderator of the panel say a few words, but you are doing what we want you to do, and that's ask good, direct, hard questions, interchange. We are going to be here for 2 days. If you don't get all your answers, you can pinpoint somebody for answers. I'm delighted the students are here. This is how we learn together. It's really been a good example so far. Mr. Moderator.
Ben öyle hissettim ki bu kadar didaktik, bu kadar öğretici, bu kadar interaktif bir metot ikinci etap olarak kullanılıyor. Bizde daha birinci etap henüz tamamlanmadı. Nedir o? Hukuk, adalet, insaf meseleleri insanın içine işletilmedi. Hukuku içselleştiremedik. Hukuku biz cümleler, çeşitli ifadeler olarak anlatıyoruz, yazıyoruz ama uygulamada, tatbik etmede zorluk çekiyoruz. İşimize gerçekten sindirebilmiş olsak, zannederim bu metotlara, bu usullere çok kolay intibak edeceğiz. Benim arzum, henüz yapamadığımız, daha aileden başlanması gereken doğru olmak, dürüst olmak, adil olmak, hak yememek, etik davranmak, bunlar bizde var görünüyor. Fakat Sayın Profesör'ün bahsettiği çıkar çatışmaları günlük hayatımızı son derece bürüdüğü için herkes kendi menfaatini en fazla korunmaya muhtaç taraf olarak görüyor. Halbuki ortalığın, ortak menfaatin korunması var. Ortak menfaatin korunması zannediyorum Türkiye'de çok zayıf olan bir düşünce. Bu faaliyetler eğitimle tabii gelişecek. Eğitimi biz tek hocanın konuştuğu ağırlıklı olan, hocanın konuşmasının ağırlıklı olduğu bir sistemde yürütüyoruz. Dolayısıyla ikinci etaba henüz geçemedik. Tabii geçmiş olan hocalarımız, geçmiş olan fakültelerimiz vardır. Yapmaya çalışıyoruz, farkındayız. Fakat birdenbire de olmuyor. Aile içindeki iletişimler, anne babanın kendi rollerini iyi oynaması, o iyi oynanmış roller içinde çocuğun kendi rolünü öğrenmesi karşılığında, dürüst bir ortamda büyümesi karşılığında gençler bu rolleri de ortak menfaati korumak üzere gayet güzel oynayacaklar. Bizim baş problemimiz sayın profesörlerim, zannediyorum özümseyememek, adalet duygusunu, hukuk duygusunu, hukukun üstünlüğü duygusunu özümseyememek ve kurallara tam manasıyla bağlı olamamak. Çıkar maalesef günlük hayatta en ön planda gidiyor. Biraz da ekonomik gelişmeyle de alakalı zannediyorum. Bir sistem, çok ağır bir sistem içindeyiz. Liberalizmi diyelim, kapitalizmin vahşisi mi diyelim, gerçekten sosyal adalete ihtiyacımız var. Bunu en küçük birim olan aileden, okuldan, işletmelerden, firmalardan, fabrikalardan, bürolardan, her taraftan fışkıran bir benimseme duygusunu inşallah bu konuşmaların neticesinde birbirimizi etkileyen bu görüşleri ortaya koymak suretiyle Barolar Birliği'mizin tertiplediği ve benzeri daha tertiplenecek olan faaliyetler sayesinde muhakkak ki bir gelişme olacak. Ben sevgili iki konuşmacıya da, kıymetli misafirlerimize de hoş geldiler diyorum ve teşekkür ediyorum.
Now, as before the panel steps down, I'm informed that our wonderful Turkish bar hosts have a special presentation to each panelist.
Efendim, değerli konuşmacılara konuşmalar için teşekkürlerimizi arz ediyorum. Kendilerine bugünün hatırası olarak birer plaket vermeyi düşündük. Ancak bunun yerine kendilerinin adına ağaç dikilmesinin daha uygun olacağını değerlendirdik ve bu nedenle temaya bağışta bulunduk. Söz konusu bağışımızın sertifikaları hazır. Bunları takdim etmek üzere Türkiye Barolar Birliği Başkan Yardımcısı Sayın Avukat Berra Besler'i kürsüye davet ediyorum efendim. Sayın Sacit Adalı. Buyurun efendim.
Sayın Hocam, katkılarınızı değer verdiğiniz için hakikaten çok teşekkür ediyoruz. Aslında tabii ki bildiğimiz ve vaktiyle uygulamakta olduğumuz hukuk öğretimi
Berhan
ve eğitimi yine birlikte yapılması elbette bizim en büyük dileğimizdir. Olaylara sadece eğitim öğrenme açısından değil, hukuk devleti açısından bakılması da çok önemlidir. Nitekim hukuk fakülteleri yıllardır sadece öğrenim vermekte, bizde eğitimi ihmal etmektedirler. Oysa hukuk yaşayan bir ilimdir. Tıpkı tıp ilmi gibi insanla birebir ilişkisi olan ve insana doğrudan etki yapan, birisi sağlığına yapıyor, biri hayatına yapıyor. Bu etkiyi çok önemsenmesi gereken bir eğitim ve öğretim alanı olmalıdır hukuk fakültelerimizde. Vaktiyle öyleydi. Aynen sizin son ifadelerinizde buyurduğunuz gibiydi. Ama son yıllarda vakıf üniversitelerinin de fazlalaşması dolayısıyla bunda büyük aksaklıklar görmeye başladık. Neden eğitimle öğretim bir arada olsun diye çırpınırız? Çünkü hukuk fakültelerinden nitelikli hukukçuların yetişmesi çok önem taşımaktadır. Nitelikli hukukçular arasından hukuk uygulayıcıları olacak olan hakim, savcı, avukat ve noterlerin işlemleri doğrudan doğruya hukuk devletini etkiler niteliktedir. Bu itibarla çok önemlidir. Onun için ben sayın konuklarımızın ve sizin açıklamalarınızı son derece önemli buluyorum. Ama bunu bozan inanın aileler değil, inanın hukuk fakülteleri değil, siyasi iktidar ve politikacılardır. Onlar da inşallah günün birinde bu hukuk eğitiminin hepimiz için yaşamsal değeri olduğunun bilincine varırlar ve biz hukuk uygulayıcılarını yetiştiren ve insanlığa çok önemli olan barış, huzur ve kardeşliğin temelini teşkil eden hukuk bilincini daha ilk öğretimden itibaren yaşamımıza sokarız ve hukuk devletini hep birlikte yaşatırız. Çok teşekkür ediyorum. Ve bunu da bugün aslında size sunmak istiyorum.
Son derece sevindirici. Temennilerine katılıyorum. Gayet güzel, doğru ifadeler. Hepsi bizim değişim geçirmemizi gerektirdiğimizi gösteriyor.
Politik değişim ve anlayış.
Evet, bir anlayış farkı inşallah ereceğiz. Sağ olun.
Teşekkür
Sayın Profesör James Moliterno, Sayın Profesör Jane Ching.
Thank you very much.
Thank you. Thank you very much.
Evet, sözü tekrar devrediyoruz.
You'll find the next subject matter very interesting as Professor Lucy Jewell takes the stand. Think about the future, think about how rapidly the world is changing, and then open your mind and hear what she has to say about what we need to be doing. It will be fascinating to you all. So I will turn it over to the panelists at this time. While the panelists are working with the technology, look around you. All of you are very important to the future of legal education, not just in Turkey, but as we look at our American and British guests, all over, all of us are the ones who are going to hopefully point the way to the kind of changes in the future. There will be changes, we know there will be changes, but if we work together and keep those fundamental principles that our moderator has talked to us about in our minds as we make the changes, we'll make good changes. Then I would like to request that I be given a great deal of sympathy. It's supposed to be the policeman, but the questions are so good, it is hard to stop the questions. It really is important that this interchange go on. Ready?
Merhaba. Merhaba. I'm going to talk to you a little bit about trends I am seeing in the United States concerning the future of the practice of law. How is the practice of law changing? How is technology impacting what we do as attorneys? And what can we expect in the future? And my focus today is what is the future of the independent practitioner, or what I am terming the indie lawyer. And here I'm talking about lawyers who decide that they want to go and practice law, they're not tethered to a firm or a company. So my research comes out of work I did in 2011, which looked at how the internet impacted the legal profession in the United States. And at that point, the internet, blogs, disrupted and changed the conversation about the legal profession, about legal education. And what we had out of that movement was new voices challenging the legal profession and challenging the value of a legal education. So we had stories that were growing out of the internet about how law school was a poor investment. Going to law school was too much money, and you did not get any real value out of your law degree. And that opened up the conversation that Professor Moliterno was referring to about the crisis in our legal education today. And from that, we had some positive things, such as Professor Moliterno's program at Washington and Lee, such as other law schools in the United States who are seeking to make legal education more relevant to what the practice of law is really like. But the bottom line is that we are all very worried about jobs. Graduates who are graduating from law school, the numbers are not good in terms of how many law graduates are able to get a job at a law firm or at a government. So the trend is to consider what is the possibility that law graduates can go, after they get their degree, go out and start their own practice, become entrepreneurs and forge their own individual path into the profession. And how can technology aid this process? That's what I am most interested in looking at, and that's what I'm speaking with you today about. And I would be very curious to hear whether or not these same trends are impacting Turkey in the way that they are impacting, or in a similar way that they are impacting the US. So 3 questions I want to talk to you today about. What are the cultural and theoretical trends that are shaping the legal profession? How will the legal profession be changing to create this new style of lawyering? This new lawyer that I am seeing, what are the attributes? And what do we need to do in terms of our institutional rules to foster this type of lawyering? So let's start with some economic theories. It used to be, for most of the 20th century, that production was maintained by a firm, and that one business controlled the means of production. Supplies, transportation, everything was produced under one roof. That has changed now. Technology has changed that such that we are now in a much more fluid economy, and companies no longer control every aspect of production, and they may, through networks, source out those means of productions so that you no longer own the warehouse, for instance, that you are shipping goods out of. You may no longer even have control of the goods that you are selling. You are creating a network to allow third parties to sell their goods through your hub. And that is the model in a company such as Amazon. So with that networked, more fluid means of production, we have less stability in the firm. There is less of a chance nowadays that you can go get a job at a firm or company and have a secure career for your lifetime. Work in all aspects of the economy has become much more precarious. So in response to that, we are seeing movements looking at sustainability, resilience. What can we do to ensure that our work is under our control? What can we do to make sure that what we buy remains in our community? Because there's this idea that knowing where our products come from and putting value in our community is going to create a more sustainable way of making a living for everyone. So I'm interested in seeing how do these theories impact the practice of law. So a couple of other theoretical points here about how the internet has changed how we practice law. The first is this idea of community. It used to be that community was defined by the places, the physical places that you go. So what school, what club, those institutions defined your community. But now with the internet, you can go online and find like-minded individuals and form an online community. And those communities have the same attributes of sharing and community that a physical place does. So that has changed. Participation is another important cultural trend. And this is the idea that on the internet, everyone can participate. Everyone can contribute their intellectual capital to make a product. And the internet allows people to work together who live far apart. And this is a different kind of production. And we see it with open source software, and it has become very, very valuable. And then there's also this idea of the internet allowing people to make things and sell things on their own without having to go through a middleman company. So through a website, you can make things on your own and sell them. And it's given rise to, in the United States, this very strong trend towards doing it yourself, selling things and making things independently. And finally, new technology has opened up new markets. The first trend is the idea that we are, as consumers, we want things that are specially made for ourselves, bespoke products. Number two, the internet has opened up a new kind of business called the sharing economy. Companies like Airbnb, TaskRabbit, they allow individuals to use the internet to make money off of their excess labor, or they're leasing out their apartment to others. So it's a way of sharing excess capital and to make additional money. Bike sharing programs is an example of sharing that has become very popular. And then there's also the idea of social enterprise. And social enterprise is the idea that you are making money as a company, but you are also, in making money, doing good for the world. So a company like Tom's Shoes sells shoes, but they make it very obvious in their marketing that some of their profits go to helping children who cannot afford shoes to buy shoes. And then finally, the long tail is the idea that there are niche markets that did not exist before the internet. But because the internet allows a seller to widen the scope of customers, there is space to make money from products that are very specialized. So let me give you an example from Turkey of the long tail. So Anatolian rock. Have any of you heard of any of these artists on my slide? A few of you. So in the United States, if you were to go to a store selling music, you would not be able to find Anatolian rock. But there are locations on the internet where people can go to listen to and purchase this kind of music. You would not be able to make money if you opened up an Anatolian rock store where people had to walk to. But on the internet, you can have a business specializing in Anatolian vinyl records. And because there are enough people around the world with an appreciation for this niche market, you are able to actually make money. So that's an example of the long tail in internet marketing. Okay, so thus far, in terms of law and technology, one trend is seeing how technology enables legal products to be packaged, mass commodified, and basically it is a one-size-fits-all situation where you, the consumer, go out and buy a contract, for instance, but there is no face-to-face interaction with an attorney. So I'm interested in seeing how can technology bring attorneys and clients together in a one-to-one way. And I do think that technology and the trends that I've talked about are giving rise to this potential. So the indie lawyer, the independent lawyer, what are her attributes? She is independent. She does not practice through a company or a firm. She might practice with a small group of other attorneys, but she is not working at a large institution. Her focus is on helping people solve real problems. She adheres to a craft model of law production. So she is trying to make legal solutions that are tailored to the individual needs of the client. She embraces cooperation and she taps into the sharing economy. In the United States, we are seeing sharing lawyers, indie lawyers, a few. This is Janelle Orsi, who practices law out of Berkeley, California, and she's written a book about how the sharing economy has enabled her to thrive as an independent lawyer, practicing this new type of law and helping people make business connections in a cooperative economy. So one more thing. I've been using the term the indie lawyer, and I just want to explain that in the United States, the term we normally use for an attorney who practices by herself or himself is a solo practitioner. And in the United States, solo practitioners are viewed somewhat with disdain. Definitely you have more status if you work for a large firm or if you work for an elite segment of the government. But because of the crisis in our economy, which has morphed into a crisis in legal education and the legal profession, I believe that we need to rehabilitate how we view the solo practitioner. And we want to celebrate the ideal of the autonomous lawyer going out and forging his or her own path into the profession. So I will close just with my ideas of how I do believe that there is space in the legal market in the United States for capturing niche markets for the long tail, creating contracts, entertainment contracts, online dispute resolution, small business transactions. If you cast your net wide enough and you use technology to bring the clients to you, I do believe there are spaces for the law profession to grow here. Thank you.
Mrs. Yu'la çok teşekkür ediyoruz. Gerçekten uygulamanın ne kadar farklı olduğunu bize gösterdi. Şimdi sorulara geçip Sayın Yenis'e söz veriyorum. Buyurun efendim.
Sayın Lucy'le çok teşekkür ediyorum bu aydınlatıcı konuşması için. Gerçekten bizim çocuklar bir gitar yapmak istemişlerdi. Bildiğiniz gitar. Ve internetten gitar nasıl yapılır diye tarif aldılar. Oturup gitar yaptılar. Hiç marangozluk bilmezler, şey yapmazlar. Ama internetten her şey bulunabiliyor şu anda. Lucy'nin de verdiği fikir, internetten hukukçu bulabiliyorsunuz. Kendinizin problemini çözmeye yarayan hukukçuyu internetten arayıp buluyorsunuz ve o size gelip yardım ediyor internet üzerinden. Yepyeni bir alan hukukçular için. Fakat bizim arabuluculuk yönetmeliğini okudunuz mu? Arabuluculuk yönetmeliğinde bir yasak var. İnternet motorlarına arabuluculuk yaptığınızı da belirterek kendinizi koysanız reklam yasağına giriyor. Bizim yönetmeliği hazırlayanlar çok detaylı yapmışlar o şeyi. İngilizce tercüme ettim ben bu yönetmeliği, fakat bayağı zorlandım o kelimelerin şeyini bulmak için. O kadar ayrıntılı yasaklar koymuşlar ki. Şimdi Lucy'nin getirdiği bu internet indie hukukçu, bağımsız hukukçu, internet hukukçusu, Türkiye'de yasak maalesef. Bir avukat kendisi bu şekilde ortaya koyamayacak gibi görünüyor.
Sağ olun. Buyurun efendim. Burada. Siz söz istediniz.
Ben de Feridun Hocama katılmak istiyorum. Katıldığımı belirtmeliyim. Şöyle ki artık hayat sanal ortamda devam ediyor. Hayat sanal ortamda devam ettiği için uyuşmazlık da orada çıkacak. Uyuşmazlığın tarafları da çözümü artık fiziken bir yerlere gitmeyi aştık. Çözümü yine web'te arayacak, internette arayacak. Dolayısıyla hocamla aynı görüşteyim. Dediğim gibi yani yasaklarla falan olmaz. Hukukçu her mecrada hizmet verebilmeli. Bizim hukukçu için farklı ihtiyaç alanları açmamız lazım. Ve bunların da başına web geliyor. Bahsettiğiniz gibi oyun hukuku dediniz. Oyun hukuku diye yeni bir alan çıktı. Bilişim hukuku dediğimiz alan, dijital delil dediğimiz alan artık hukukun tüm dallarını kapsar hale geldi. Dolayısıyla yasaklarla bu işin ülkemiz örneği için söylüyorum çözümlenebileceği düşüncesinde değilim. Bahsettiğiniz gibi er ya da geç internet hukukçularının doğması bence var olması gündemdedir. Teşekkür ederim. Çok sağ olun.
I agree. So that was a great question. You know, do we need to change our ethical rules to catch up with where we are with technology? And it sounds like Turkey has similar bans to what we have in the United States, which is that as a lawyer, you cannot directly solicit a client. Now, in the United States, you can practice law through the internet, but it's regulated. So for Turkey, you probably would want to, I mean, I believe that direct bans on practicing law with the use of technology is not, that's not productive. And in terms of ethical concerns, I believe that the internet has a built-in mechanism to deal with that. If you are being unethical online, then you will get a very negative online reputation. And that in itself will help police attorneys and require them to act ethically when they do business online.
Bizde de internette avukatlık yapmak diye bir şey söz konusu değil. Yani biz internet üzerinden, UYAP üzerinden bazı iş ve işlemlerimizi, işte dilekçelerimizi, dava açmayı, icra takiplerini yapıyoruz. Ama internetten avukatın reklam yapması gerçekten hani kabul edilir bir şey değil. Etik kuralları, yani diğer meslektaşlarına yönelik olarak etik kuralların ihlalini çok rahat doğurabiliyor. Pardon, bunu öncelikle söylemek istiyorum. Bir de ben merak ettiğim bir şey var. Amerika Birleşik Devletleri'nde özellikle avukatların, serbest avukatların desteklenmesi gerektiğini vurguladınız. Hatta bazı serbest avukatların iş bulamama ihtimalinden bahsettiniz. Böyle bir şey olduğunu söylediniz. Fakat Amerika Birleşik Devletleri'nde şirketler aracılığıyla bu iş yürümekte. Yani aslında şirketler aracılığıyla yürüdüğü için böyle bağımsız ofis açmanın da zor olduğu ve desteklenmediğini düşündüğümüzde aslında da orada sıkıntılar olduğunu algılamaktayız. Peki böyle bir destekleme bakanlığın ya da işte herhangi bir kuruluşun böyle bir desteklemesi söz konusu var mı? Ya da tamamen yoksa bankalardan ticari amaçlı bir ticari meslek gibi algılanıp, ticari faaliyet gibi algılanıp bankalardan ticari kredi kullanılarak mı desteklenebiliyor? Bunu merak ettim. Teşekkürler.
That's a wonderful question. So if you are an attorney in the United States and going out on your own, there is not a lot of governmental support for that. So you find support through your community of other attorneys who are doing what you do. There are some solo practitioners that work in an office space together, and they are able to rely on each other there for support, even though they are not incorporated. But I do think that solo practitioners, and I've seen this, there are listservs, there are websites out there where solo practitioners can go and receive information and exchange ideas with each other, and thereby, in that way, support each other using the internet. But the problem you identified is a very important one, which is that the law firms make it's a much more secure way to practice law. There's much more of a safety net there. And when you are out there on your own by yourself, it can be very, very scary. And I also think the other problem, at least in the United States, though, is that law firms are shrinking in response to economic forces. There just aren't that many jobs available in law firms. So if you want to enter the legal profession, a lot of times your only choice is to go out and try to practice law on your own.
Thank you all very much. What we're going to do is move our panel that was scheduled at 10 o'clock on with our justices, and we're going to have a break right now. 15-minute break will begin right now. Thank you all so much. Together and get settled in, I want to say a word or two about our two speakers. This group we are truly honored to have with us today two of the most prominent American jurists. Both of our speakers have been Chief Justice of their own state Supreme Court. They're both members of their state Supreme Courts. Both of them, while on the bench and Chief Justices, have been very active in legal education and the issues of legal education. Let me tell you a little bit about them. It is extraordinary to have people of this importance with you. Justice Carol Hunstein, while she serves as Chief Justice, was also a member of the Board of Directors of Atlanta's John Marshall Law School. She was a hailed, wonderful Chief Justice of the Georgia Supreme Court. Christine Durham was Chief Justice of the Utah Supreme Court and has also been chair of the Legal Education section of the American Bar Association. That's the section that helps modernize rules regarding legal education and the accreditation of law schools in the United States. So you've got two incredible speakers. Both have been Chief Justices of their state Supreme Court and still sit on those state Supreme Courts. And both are deeply interested in the issues of modernizing and helping legal education solve some of its problems. So I thought it would be important for you to know about that as you hear these two speakers speak.
Teşekkür ederim Sayın Profesör. Şimdi bu kısmın ilk konuşmacısı Mrs. Christine Durham. Buyurun.
Good morning. I wish to express gratitude to our Turkish hosts and especially to Professor Yanasi, who has helped to bring us all together for this very interesting discussion. My colleague from the state of Georgia and I have the task this morning of giving you a brief overview of the ways in which the judiciary in the United States is active in and responsible for the admission to practice and the regulation of the legal profession. This, of course, has great significance for legal education because it's the standards for admission and the standards for practice for which students in law school must be prepared. So the work that you do in the law schools and that we do on the bench in our country is extremely important. There are two distinctive aspects of the American system of regulation of the legal profession that I wanted to mention this morning. The first is that the regulation of the legal profession in America belongs to the states, not to the central federal government, but to the individual sovereign states. There are 51 of us, And from the beginning of our tradition, it has been the state courts who have been responsible for allowing lawyers to practice in their courts and to practice law, and have been responsible for protecting public interest and taking care of the public good in those states. So number one, lawyer regulation in the United States belongs to the states and not to the federal government, historically and traditionally. And number two, it has historically and traditionally in the United States belonged to the courts, not to the legislative branch and not to the executive branch. And that's something that I think is distinctive around the world in many systems. And I don't know enough about Turkey's and hope to learn more. But in many other systems, the executive branch and the legislative branch have much more to do with the regulation of the legal profession than do the courts. So, having said that there are two distinctive characteristics, let me say just a few words more about each of them. First of all, the responsibility of the states for regulating the practice of law means that there are a number of challenges that we are facing in the United States right now with respect to the regulation of the practice. The first is the challenge to uniformity and mobility. Every state has its own standards and its own process for admitting lawyers and for permitting them to practice. So if you are admitted to in the state of New York, you know, you think it's hard as foreign lawyers to come to the United States and practice. It can be it's not terribly hard, but it requires time and money and an application and sometimes a testing process just to move from the state of New York to the state of Georgia to practice law. So that's one feature of our system and that we are trying to deal with. The second, of course, is related to it, and that is the need to accommodate the increasing numbers of lawyers from foreign jurisdictions outside the United States who wish to practice in our courts and in our systems. Then you have challenges to the law schools who are preparing these students for practice. The activities that a single state may undertake, if it's a large enough state and an important enough state, may have implications for law schools all over the country. For example, the state of California, and California is an extremely large state, larger than many countries. The State Bar of California is currently considering and will likely implement significant requirements in what we call experiential learning. You've heard a reference to that earlier this morning, and we'll be talking about it more in the conference. But they're requiring a minimum number of hours spent in that particular type of education. That means that any law school in the country, from Harvard to the University of Utah, will have to provide that specified number of hours in that type of education in order for their students to be eligible to take the California bar and practice in the state of California. So you have this problem that the states have had historically enormous power on policy around regulation. And then you have many challenges to the management of discipline and the protection of the public across jurisdictional lines. So that's just a quick overview about what it means for us to be a federalist system, a dual system where the local or state governments have responsibility for managing the practice of law. Let me speak about the second feature I mentioned, and that is the fact that the regulation of the practice of law belongs to the courts and not to the legislature or to the executive branch of government. The high courts of each state, the state supreme courts, and those are the courts on which my colleague Justice Unstein and I sit, have either constitutional or common law and historical authority over admissions to the practice of law, over lawyer regulation, and that often includes the regulation of the unauthorized practice of law, which, although a criminal offense in many states, is also subject to regulation by the courts in many states, and over lawyer discipline. We have increasing efforts going on in our country towards more uniformity and cooperation around these kinds of issues. There is an organization in the United States known as the Conference of Chief Justices. Justice Hunstein was a member for many years. I was a member and chair of that conference for a number of years. And one of the things the conference works on is trying to encourage collaboration, communication, and an increase in uniformity over such issues as the practice of law, so that there aren't so many barriers between our jurisdictions. The Conference of Chief Justices has an administrative arm known as the National Center for State Courts. They do a great deal of research on how the states administer their courts and on how they regulate the practice of law, and that's a very useful thing. One other thing you might be interested to know about is a recent report from the Task Force on the Future of Legal Education, sponsored by the American Bar Association. Its report was issued last February, and it contained recommendations to the many sectors interested in legal education, and there was a section of the report directed specifically to state Supreme Courts, to state bar associations, and to other regulators of lawyers and law practice. There were a total of 6 recommendations. I'll just briefly mention 3 because they relate closely to the judicial branch's responsibilities. One was that the states are encouraged to establish uniform national standards for admission to practice as a lawyer, including adoption of something you'll be hearing about from one of our other speakers today, the Uniform Bar Exam, which is an examination that's been developed. It can be modified by individual states, but it's intended to give a uniform admissions exam. The second requirement or recommendation that I'll mention is a recommendation that the states reduce the number of doctrinal subjects that they test on their individual bar exam and increased testing of competencies and skills. We're hearing a lot about competency and skills in connection with legal education, and we're also hearing a lot about the idea of focusing on outcomes, on what law graduates can actually do when they finish law school, as opposed to simply approaching law schools from what they put into legal education, focusing instead on what they get out of legal education. And this idea is that when lawyers are seeking admission to practice law in our states, the states should likewise be focusing on skills and competencies. And then the third recommendation of the ABA report is that states should avoid imposing more stringent educational or academic requirements for admission to practice than those that are already required by the American Bar Association's standards for approval and accreditation of law schools. Now, of course, the state of California is going directly contrary to that recommendation in its efforts to impose higher standards for a particular type of education for people sitting for its bar. I would mention, in addition, that there are numerous state-specific experiments going on, and 2 that come to mind immediately come from Justice Hunstein's state of Georgia, so I'll leave it to her to speak about those. But that has to do with ways to cope with the admission and regulation of foreign lawyers who wish to practice law in individual states, mentoring programs for new lawyers so that when lawyers finish their legal training, they have opportunities to work with more experienced lawyers, modeled to a significant extent on the British system of pupilages. And then in other states, the Supreme Courts are looking at the creation of limited license categories for regulation. You saw how many categories there were in the UK. In the United States, we just have lawyers, but we are thinking about having people who do specific tasks and only need to be licensed and regulated to do those tasks. There are projects looking at nationalizing the databases, the information sources for information about lawyers across boundaries so that their character and fitness and ethical behavior can be regulated. And then, as I mentioned earlier, there's focus on the adoption of uniform bar examinations across the United States. We believe in the United States that lawyers play a significant role in a democratic republic, and that they are essential in their functions to the health and the strength of the rule of law. From the founding of our nation, lawyers have played a tremendously important part in the development of our tradition and values. There are, as we're discussing at this conference, ever-increasing and enormous changes and pressure for change in our profession and in the education of our lawyers. But one of the things we hope in the United States is that as we adapt to these pressures and accommodate the changes that are required for the health of our economy and our society, we will not lose sight of the essential function of law and lawyers in the process. Thank you.
Sayın Kristin Dürhem'e çok teşekkür ediyoruz. Taraflardan biri olarak kendilerini ifade ettiler. Şimdi aynı taraflardan biri, bir başka biri, Sayın Carol Honstein. Buyurun.
Thank you, and let me say that I am delighted to once again have the opportunity to visit Turkey and to participate in programs here. And Professor Yenisi has been just wonderful, as always, with his reception, and we have enjoyed our relationship with the Başakşehir University. Let me start by saying that the practice of law has historically been considered to be one of the three true professions. There is theology for the preservation of the spirit, there is medicine for the preservation of the body, and the law for the preservation of civilization and attendant world affairs. Justice Durham has given you kind of an overview of licensing in the United States. I want to give you a little bit more specifics. In general, it requires a 4-year undergraduate degree in just about any area where you can get a bachelor's degree. It requires a Juris Doctorate from an ABA accredited school or university. You must also pass a character and fitness review to determine if the applicant will properly assume the responsibilities of the profession and pass a bar exam that tests the applicant's knowledge of the laws of the United States, the state law, including federal and state constitutional law, common law, criminal and civil practice, and sometimes other areas. And that is administered in each state. There is a recent amendment to the rules in the state of Georgia that will allow admission to the practice of law for foreign educated lawyers to sit for the bar exam if they have successfully completed the LLM program for the practice of law in the United States and meet the other requirements of the rule. And Sally Lockwood, who is our Director of Admissions to the bar exam in the state of Georgia, I'm sure will talk more about that. There's also reciprocity between the states. Not all states will give reciprocal admission to a lawyer if they pass certain requirements of that particular state, which means if you have passed the bar in one state, you can waive into another state with certain limitations. As I said, not all states do practice reciprocity. Florida, for one, thinks all lawyers want to retire to Florida, and so there is no reciprocity. I don't care where you're a member of the bar. There is also pro hac vice, which means that if a lawyer who is admitted to the practice of law in another state has a case in the state of Georgia, there is a method for them to apply to present themselves and represent their client in that one case. They would apply to both the trial court and to the appellate courts, and that happens frequently, I think, in every state across the United States. Of course, there is discipline that is administered by the court system, and our state bar in the state of Georgia may receive a complaint. We have set out the canons of ethics that lawyers must abide by. If there is a complaint and the state bar decides that it has some merit, and many have no merit at all, but if it is indicated that there may be an ethical violation, then a special master is appointed who will then have a hearing and have both the attorney and the accusers come in and have a hearing to determine whether or not discipline is required. Then that recommendation, if there is an ethical violation, will come to the Georgia Supreme Court for disposition, and the sanction that can be imposed ranges anywhere from a letter of admonition, which is private, and just says your conduct is not acceptable, to disbarment, which means that you will no longer be able to practice law in the state of Georgia. We also have reciprocal discipline, where if a lawyer is admitted to practice in more than one state and they're sanctioned by another state, then the state of Georgia can impose reciprocal discipline. I will tell you, though, frankly, that in general, we impose much stricter sanctions than what our sister states do. As I said, some complaints received by the state bar may not involve an ethical violation, but the conduct of the lawyer is still of concern. And the state bar has developed other programs to address these issues, one of which is the voluntary fee arbitration. And it is voluntary as far as the lawyer is concerned. Of course, if the lawyer refuses to engage in fee arbitration, then the client can file in court and air their complaints in that fashion, which is not necessarily a good idea. Georgia also was the very first to develop a mentoring program. And every young lawyer who recently passes the bar in the state of Georgia is assigned a senior lawyer who's been approved by the Georgia Supreme Court to guide them, not to do their cases for them, but to give them guidance. Basically, a professional lawyer who's been in practice for a long time, who is well respected, and they will help this lawyer to understand what the practice of law is all about. We also have the Third Year Practice Act, which allows students who are still in school to engage in some activity under the guidance of a lawyer. Frequently, it is with the public defender's office or with the prosecution. There are other instances where lawyers can engage or law students can engage with the guidance and help of a seasoned lawyer. And those are all approved by the Georgia Supreme Court. We also have internships and externships where they can come and work at the court for course credit. Externships in Georgia, you are paid a fee, but internships is strictly for course credit. They're also started in the United States, and Georgia doesn't quite have one yet, incubator programs where young lawyers who have graduated and can't get a job and can't afford to start their own office have the opportunity to have a reduced rate of office expense, and they are gathered together in a common office, and they have administrative help as well as supervision by a senior lawyer. Georgia started the professionalism program in the United States. It was felt that lawyers although they were complying with the ethical rules of conduct, and they were not violating those rules and were not subject to discipline, that they were not acting professionally. They were not being courteous to the court, they were not being courteous with each other, and that the idea was to win at any cost. Georgia has had that program for about 20 years now, and I think it has spread across the United States and to some other countries, to teach lawyers that it's important always that we act as professionals. We're not merchants. We don't sell goods. We are professionals, and we must treat each other and the court system and our clients with the professional and morals that our parents taught us. To be honest, to be diligent, to always strive to do the best for your client, and not just to win. Thank you.
Sayın Honstein'a çok teşekkür ediyoruz. Şimdi bu konuşmalar ışığında soru faslına geçebiliriz. Buyurun Feridun Bey.
İlk sözü ben hep alıyorum ama hoş geldiniz, merhaba. Bu Justice Honstein'in en son söylediği kelimelerle başlamak istiyorum. Bir avukatın görevi her zaman kazanmak değil. Kazanmak için her şey mubahtır fikrinin olmayacağını söyledi. Gerçekten de etik kurallarının çok önemli olduğunu görüyoruz bütün hukukçular bakımından. Her iki konuşmacı da baroların bağımsızlığı ile ilgili bazı görüşler ortaya koydu. Bakınız, Amerika'da şunu anlıyoruz ki hukukçunun mesleğe başlaması için, profesyonelce çalışabilmesi için mahkeme bir işbirliği yapıyor. Mahkemeden görüş geçiyor. Mahkeme o profesyonelliği kabul ediyor. Ne kadar eğitim almış? Ve şuna bakıyorlarmış en son anladığım kadarıyla. Uygulamalı eğitim, aldığı eğitimin ne kadarını oluşturuyor? Ona göre baro, avukatlık yapmasına falan izin verecek. Fakat mesele şu, barolar mı söz sahibi, yürütme mi söz sahibi, yargı mı söz sahibi? Yani burada baroların bağımsızlığı kavramını tartışmamız gerekiyor. Avukat bağımsızlığı, baro bağımsızlığı. Baroların meslek kuruluşu olarak ülke içerisinde ayrı bir yerleri var. Bağımsız statüleri var. Fakat avukat da bağımsız. Avukat barosuna karşı bağımsız olmalı, yürütmeden bağımsız olmalı ve müşterisine karşı, müvekkiline karşı da bağımsız statüsü var. Fakat bu bağımsızlığın ölçütü ne? Nereye kadar bağımsız? Zannediyorum bunları tartışmak gerekecek. Öğrencilerimiz için bir müjdem var. Justice Honstein bu externship'ten bahsetti. Staj yapabilirsiniz Amerika'da. Hocayla tanışın, yargıçla. İstanbul'dan bir öğrenci aldı. Belki bir tane Ankara'dan da kabul edebilir. Sizlere bir yol açılabilir.
Teşekkür ederiz.
I would like to, could I respond? It's a very interesting question as to the relationship between the courts and the bar associations. And there are at least two different systems in the United States. My state has what is known as an integrated bar organization, and they do not exist, legally speaking, independent from the court. The court has the constitutional authority to regulate the profession, and we delegate the administrative, we make the rules, but we delegate the administrative functions associated with the regulation of practice to the bar organization. Now, they have some history and separate roles for providing professional support to lawyers and so forth and so on, but they can't do anything in those roles that the court could not do or that we would not permit them to do. Now, in other states, that's a different situation. The court, which has the authority to regulate, sets up its own administrative system for regulatory purposes, and the bar is in the nature of a trade association of lawyers to provide benefits for lawyers. There's debate in our country about which system is better. Of course, we all like the system we have because we've learned how to make it work. Justice Hunstein may have some comments on that too.
I agree with you. There are differences as far as across the state is concerned. Georgia also has an integrated bar, and it seems to work for us very well.
Teşekkür ediyorum konuşmacılara, değerli fikirlerinden, paylaşımlarından dolayı. Ülkemizdeki sistemi herhalde İstanbul'daki toplantı fırsatıyla değerli misafirlerimiz tanıma imkanı, fırsatı bulmuşlardır. Ülkemizde özellikle avukatlığa geçiş anlamında hiçbir sınav olmadığını galiba duymuşsunuzdur şaşırtıcı bir şekilde. Ve yine hem avukatlığa hem hakim ve savcılığa başlama yaşının maalesef çok genç olduğunu, maalesef diyorum, ben de çok genç bir savcı olarak başladım bu mesleğe, bunu üzülerek ifade etmeliyim. Bu anlamda ülkenize dönecek olursak, ülkenizde hiç sınav olmayan bir sistem olduğunu hayal ederseniz karşınıza neler çıkar? Bunu düşünebiliyor musunuz? Hiçbir sınavın olmadığı bir avukatlık sistemi veya kendi mesleğim hakimlik savcılık için söyleyeyim, sadece stajdan sonra sınava başvuranların neredeyse tamamının %100'ünün başarılı bulunduğu bir hakimlik savcılık sistemi. Böyle bir sistem sizce hukuk devletinde, demokraside nasıl bir karşılık bulur? Nasıl bir ortam doğurur? Bunu sizin ağzınızdan dinlemek istiyorum. Teşekkürler.
That's a very interesting question. As I understand the question, it's what the Turkey's system does not require examination. And did I understand you to say that almost all applicants are in fact accepted to practice law? Perhaps it's because we are such a huge country and have such high volumes, but I frankly cannot imagine such a system working well for us, in the sense that it's hard enough for us with our system of application, testing, and review to secure lawyers who are well trained in the substance of the law, who can write clearly, who are successful advocates, who know enough about the professions they're entering, such as the criminal law, domestic law, commercial law, to function effectively as lawyers. So again, it's perhaps because we like the devil we know as opposed to the one we don't, but I would find Turkey's system very daunting to us from a regulatory point of view.
It is the system that we know, and in spite of the fact that we have very stringent rules and regulations before you can even take the bar, it does not necessarily mean that you are going to be the best lawyer, that you will be successful professionally or financially. I think there is a lot of difference between being a student and doing well academically, both undergraduate and in law school, and actually engaging successfully and being honored by your colleagues in the practice of law. I think the system works pretty well. There are, even in spite of that system, there are a number of people who take the bar exam, who do not pass, in spite of the fact that they have had a very good education. Once you are a member of the bar, you can practice in any area of the law that you choose. There is no special exam to be a prosecutor or to be a judge. As a matter of fact, in some states, and Georgia in particular, a judge can run for office and the voters will elect you or not. In general, judges get to the bench in Georgia by the governor initially appointing them after going through a committee that sends names over to the governor. These are the best candidates. If you pick any of these candidates, they will meet the competence and criteria that's required for that judicial position. But there are instances where judges are elected to the bench, sometimes the general jurisdiction trial court, sometimes the appellate courts, and they have not gone through the appointment process at all. Some are successful who are appointed, some are successful who are elected. But it is an interesting system in the state of Georgia. Once you pass the bar, you can practice in any area of the law, you can become a judge, and go all the way to the appellate court, as Christine and I have. So,
I'm thinking more about your question. To some extent, I suspect that cultural values matter a great deal. Mm-hmm. We rely on objective criteria. They do a decent job, but by no means a perfect job of getting qualified people in the profession of law. But we have bad lawyers. We have lawyers who get licensed and who are not competent lawyers. And some, I wonder, I don't know enough about Turkey, but I wonder if you have developed a cultural expectation that no one will apply unless they have those aspirations and values to perform at a high level. And perhaps that's why the system works for you. But I suspect that the cultural expectations have a big impact on any system.
I agree with that. And as I said, there are students who have gone through undergraduate school, gone through law school, but they apply to take the bar in the state of Georgia or any other state, and they have to go through the fitness review to determine whether or not, in spite of the fact that they have been successful academically, that they have the moral character to be a member of the bar. And there are those who are denied membership. They are not allowed to take the bar exam at all because they did not pass the fitness exam. A couple of questions.
Durmuş hocam.
Teşekkür ederim. Tabii her ülkenin kendine has bir takım gelenekleri var. Biz Türkiye'de başlangıçta bir tek İstanbul Hukuk Fakültesi, daha sonra Cumhuriyet'ten sonra Ankara Hukuk Fakültesi de kuruldu. Uzun yıllar iki hukuk fakültesiyle yürüdü. Dolayısıyla başlangıçta katiplikten gelen dava vekilleri de olmuştur geçmişinde. Ama bugün hukuk fakültesi sayısı çok fazla arttığı için mutlaka bunun bir sınavla yapılması yönünde Barolar Birliği başta olmak üzere tüm barolar mücadele veriyor. Üniversitelerde de aslında bu yönde bir eğilim var. Çünkü kim iyi öğrenci yetiştiriyor, bunu yarışmayla ortaya koymak arzusu içerisindeler. Ancak hemen şunu unutmayın, bizim sistemimizde üniversiteye girerken bir merkezi sınavla giriliyor. Yani öyle kolay girilmez. Hakimlik sınavına girerken de yine aynı şekilde sınav vardır. Yani şimdi yine mevcut sistemi bile istense iyileştirmek çok kolaydır. Benim sorum da o konuda. Bizde avukatlık stajı 1 yıldır. Bunun 6 ayı mahkemelerde geçer. Sizde de böyle midir sistem? Yani belli bir kısmı Hakimlerin stajı gibi bizde hakimler de staj yapar, öyle hakim savcı olabilirler. Yani doğrudan otomatik hakim savcı olma diye bir şey istisnadır. Ancak üniversite doçent ve profesörleri için bir istisna vardır. Birinci sorum bu. İkincisi, acaba sizin sisteminizde adli müzaharet, adli yardım konusu var mıdır? Var ise baronun bir avukata adli müzaharetten bir görev vermesi halinde, yani ücretsiz avukatlık hizmeti veya bizde olduğu gibi Adalet Bakanlığı'nın düşük bir para vermesi durumunda kişi bunu kabul etmez ise bu bir disiplin suçu mudur sizin sisteminizde? Onun ötesinde acaba disiplin cezalarını barolar mı verir, yoksa mesela Fransa'da olduğu gibi mahkemelerin bir birimi mi verir? Nasıl sistem işliyor? O konuları öğrenmek istiyorum. Çünkü ilk sorduğum soru Versay baro başkanlarından bir tanesinin kabul etmemesi üzerine Avrupa İnsan Hakları Mahkemesi'nin davayı reddetmesiyle de ilgilidir. Onu da kısaca açıklamış olayım. Teşekkür ederim.
Thank you very much, Professor, for those two very significant questions. As to the first point, I think you do make the very good point, which explains another extremely significant difference between the system in Turkey and the system in the United States, namely that you have been screening applicants beginning at the university level throughout the system, and then you screen into the judiciary and into the prosecutorial system. We have a very different system. Almost everyone who wants to, who can figure out a way to make it work economically, can go to college. And things have changed recently because jobs are getting scarce, but the availability of student loans have made it, federally subsidized student loans have made it possible for pretty much anybody who wants to go to law school and can get in. There are standards to get in, gets to be a lawyer. And we have no similar system of screening or training for individualized disciplines, as Justice Hunstein was pointing out. In theory, and each state has its own system for selecting. So you've got 51 different systems on the state side, and then the federal government has its own system for selecting prosecutors and judges. So, and we don't get to intern as judges. We get to go and practice on the bench, and lawyers get to go and practice on their clients, which is one reason why mentorships are so important and connection with older lawyers. I'm very glad you asked about legal aid. That's a problem we are wrestling with in the United States. It's a terrible problem. In the criminal system, every accused person has a constitutional right to a lawyer, and the government will pay. The rates are low, but they tend to get pretty adequate representation. On the civil side, we have very little support for civil legal aid. In response to that, the courts have been very aggressive in recent years in establishing aspirations and in some cases requirements for lawyers to provide unpaid support for civil legal aid. We call it pro bono contributions. Only one state, however, the state of New York, has thus far made it a requirement of professionalism to provide pro bono services. So in New York, if you don't provide your 50 hours a year, you could be disciplined, and the discipline would be imposed by the Supreme Court through whatever mechanism it is established. In our state, it was a fight just to get a requirement incorporated into the rules that lawyers report how many hours they were spending on pro bono. The next step is that we will be requiring them to serve, and I hope I can get that done before I retire.
Yeah, as far as legal aid is concerned, there are federal monies that come to the states that's provided by the U.S. Congress. There is also state money. And we do have, in Georgia, we have Atlanta Legal Aid, which takes care of the metropolitan area. And then we have Georgia Legal Aid, which basically takes care of the rural areas. I don't feel is completely adequate. Unfortunately, there are a lot of people who would qualify for legal aid but the system, at least Georgia legal aid, I think is really overburdened, and it's very difficult for everyone to get the help that they need. Recently, there was a huge controversy that was started by me, I'm proud to say, that every lawyer should pay X number of dollars a year in addition to their bar dues, with that money going directly to legal aid, to be shared by Atlanta Legal Aid and Georgia Legal Aid. That has not necessarily come to pass. The Bar Association has decided they wanted to find other ways to raise some funds, but I think it's part of being a lawyer that you have to help, whether it's pro bono, helping people who cannot afford an attorney on your own individually, or supporting legal aid so everyone has the opportunity to participate in their justice system. If there are those who are excluded from participating in their justice system to resolve their disputes, then I think that is a failing of the justice system. Everyone needs to have the opportunity to have their disputes resolved, short of fighting in the street. So I think it's a very important aspect. Anything that in Georgia, it is only voluntary. There is no commandment, at least yet. There is no requirement that you participate with a certain amount of pro bono work every year, although there certainly are lawyers who do it voluntarily on a regular basis.
Thank you. This illustrates how important these subjects are. Your questions are so good, and the responses are so great. It is wonderful. Meanwhile, the poor policeman is trying to move the program on. What we're going to do is have the next session on bar exams and admissions start right now. We will finish that session, so we'll be only one session behind for lunch. I know it's going slower, but this is so important, and the questions are so important that I hope you'll bear with us. So if we have the presentations, and Sally Lockwood can get herself ready to come up.
Teşekkürler efendim. Türkiye Barolar Birliği adına hatıraları takdim etmek üzere Sayın Genel Sekreterimiz Avukat İzzet Güneş Gürseler'in kürsüyü teşriflerini arz ederim. Sayın... Please wait.
I'm excited about that. I love that.
Thank you very well, Ferdinand, we've been overruled. You and I have been overruled. The lunch is ready and waiting, and it's important, I guess, for the logistics that we do have the lunch now. And Sally, we got you up here, and now we're going to take you back down again. It just does show that democracy may be slow, but we move along. It's going to be lunch now, folks.
Öğle yemeğimiz 1.alt katta gerçekleştirecektir.